We are on.
Yep.
This is Law Talk. I'm Garry Wise. Why don't you guys introduce yourselves?
Omar Ha-Redeye.
Mitch Kowalski. Mitch Kowalski.
Mr. Tarantino.
Oh, you didn't hear me? I said my name. I'll say it again. I'm always happy to say my name.
Say my name.
Bob Tarantino.
Great. So it's been a while since we've had the chance to get together and just talk about stuff, at least in public. And today is going to be an opportunity. We figured we'll talk about some issues in the news. We've gone to Wise Law Blog for our legal updates. Let's talk about medically assisted suicide. Omar, you've just done a presentation to the Senate on the current bill. Why don't you give a bit of background and tell us what you think, and we'll take it from there.
Sure. Medically assisted death is the way that I tried to describe it, simply because, the connotations around suicide to begin with. And the rationale, first of all, the backdrop is the Carter case. So Carter in Canada dealt with someone who was dealing with, you could say, a very difficult condition with enormous amount of pain and was facing the end of their life. And so the situation that we're looking at is that we have individuals in Canada who are currently prevented from having physicians, let's say, terminate their life prematurely, even though they might be in enormous amount of pain. And so what we're doing is inadvertently continuously putting them in that pain or allowing them to exist in the pain, even though we know that they're in a palliative care condition. Okay, so this is the reason why the Supreme Court of Canada, in a nutshell, really said that the criminal code provision along these lines was unconstitutional. It's worth noting that in Rodriguez, an earlier case, the Supreme Court of Canada came up with the opposite position and actually upheld it. So it is interesting to see the court sort of evolve and develop in light of our understanding of Section 7 rights as well as Section 15 in light of disability rights. So my submission to the Senate was pretty straightforward and pretty simple. What we were looking at in particular was one of the elements of this is that there's a written request that can be done on behalf of somebody else. So in other words, the person who is actually seeking the assisted death doesn't necessarily have to be signing the documents. It can be signed by another individual. And so there was some concerns about that, given the fact that there would be potentially some fraud or some elder abuse or some disability abuse. And so the recommendations that we made in that respect was that we can use, for example, a video format, kind of like what we're doing here, or do something like an authentication, including an ink mark, which would be a substitute for a signature of the individual themselves, rather than having a proxy. So even though these people are quite often bedridden and have limited mobility, there may be some ways to get around that. And Garry, as I understand it, you do quite a bit of estates law, right? So how are those issues dealt with in that area?
I'm not sure what you're asking. Let me just a couple of points on the current legislation, though, that there are those who argue it goes too far in enabling physician-assisted suicide. There are those who are concerned it doesn't go far enough, and it seems that the issue that is attracting the most attention is that the proposed legislation requires reasonably foreseeable death, meaning there needs to be a terminal illness, and many of the critics are concerned that leaves out people with chronic, extremely painful conditions who, by way of prognosis, could live another 10, 20, or 30 years. Mitch, what do you think? Where do you stand on this legislation?
Yeah, I'm a little bit concerned. I mean, Andrew Coyne has written some really good pieces in the Nat Post about this. And, I guess my concern is that if we normalize suicide, what does that mean for us as a society? Those who want to expand this bill to everyone who just doesn't feel good. I'm a bit depressed. I've been diagnosed with depression, and then therefore my life's not worth living, and therefore, let's put me under.
Who wants to expand the bill to that extent, Mitch?
Well, that's my understanding from
you need to look up
people
straw man Andrew Coyne. I mean, nobody's arguing for that.
Well, what my understanding is that a lawyer for the last Supreme Court case is saying the bill is not wide enough. It doesn't follow what the Supreme Court said, and is arguing that it should be much wider. So, I just have a problem with legalizing the other side, and it's just hard for me to get my head around.
Let me jump in.
Where to draw the line on when your life is worth ending.
I'm going to jump in for just 1 second. The lawyer you're referring to, his name is Joseph Arve. He argued the Carter case before the Supreme Court of Canada, and his criticism is exactly the one I just articulated. He's concerned about all the chronically disabled people in constant pain who will not be able to avail themselves of this. And his primary concern is that the Supreme Court of Canada already dealt with that issue. And his argument is that the proposed legislation is far more limited than that which the Supreme Court of Canada has already made lawful. Bob, where are you at on this?
So I have, a variety of different concerns, but the two things which I think are worth remarking on is one element that Omar just referenced, which is it's fascinating to me that in the span of it's less than 25 years since Rodriguez, you've had this rather dramatic sea change. Well, I guess any sea change is dramatic. You've had this rather dramatic change on what historically has been viewed as, an incredibly contentious and incredibly sensitive, and probably not even necessarily a legal dispute or a matter for legal settlement. And that sort of plays into my next item, which is I'm not entirely convinced that this is in fact, something which needs to be resolved in a legal forum. It strikes me, we have laws against homicide. In many cases, probably the vast majority of cases, you're really talking about medical decisions which are being made here. To me, I worry about generally sort of the juridification of every single dispute or every single contentious issue that we as a society face. I'm not sure that we're really I'm not sure that lawyers or the legal community or sort of law as a sphere of human activity is really the one which is the proper venue for the solution of these issues. So I worry that, by creating a legal regime and imposing, sort of lawyers into the process, that I'm not sure we're resolving the matter in a way which is going to be satisfactory to anybody, frankly.
Okay,
Garry,
well, I think that. Yeah, go ahead. Go ahead, Omar. Sorry.
Okay, so no, I just wanted to respond to Bob. I don't think that that's what this is doing. What the Supreme Court of Canada has charged Parliament with doing is simply modifying the criminal code provision which prohibits this. It's a blanket prohibition. And so although there are elements of a legal test that are in there, including the reasonable foreseeability, which I agree does have some issues, all the legal system is doing is providing the process. And that process will still vary. It will vary from province to province in terms of its implementation, because the health administration is properly governed under provincial jurisdiction. So we don't know what it's going to look like all across Canada. And what we can expect, though, based on what we've seen in Quebec and is currently going on during the stay that's in place now, is that there is quite a bit of medical documentation and medical evidence. Like, this is based on the affidavits of physicians. Like in Ontario, it's an affidavit of a physician and a psychologist. So there's a psychic component as well. And that's the way in which these matters are proceeding. As lawyers and in the legal system, we're simply providing the venue and the process, as well as some of the checks and balances. But this is ultimately a medical decision, but it's a medical decision respecting the autonomy of the individual, in particular, individuals who are suffering enormously.
Well, do we need legislation at all? To follow up on Bob's thoughts, aren't we just as well off with the old provision of the code being struck down and no further legislation to limit the scope of physicians and patients' ability to proceed as they wish. Why do we need legislation at all, Omar?
I did a slaw post on this, that we don't want yet another Morgenthaler on assisted death, right? I mean, I think that's the situation here that people are talking about. How do you carve this out properly? And so the situation that we have in Canada is sort of ambiguous, that abortion isn't legal, it's not really illegal, it just happens, and there's no statute governing, and that might be fine for abortion because we're dealing with different issues, but they're comparable issues in terms of what we're dealing with here. If we don't have any guidelines or regulations in terms of the criminalization, maybe that's okay, and maybe it'll be regulated, like I said, at the provincial level. That's possible. But if the provinces delayed it, what we may have, especially because there's universality and accessibility under the Canada Health Act, you're going to have individuals who are going to travel all across Canada from one province to another to look for the statutory regime provincially that perhaps is more likely to allow them to get this procedure done. So the criminal code, the federal amendments that are in question here, is simply carving out where the limits to this assisted death will be found. And I will note that it actually limits it more than what Carter was dealing with. So, it's not including minors as well, which is a big issue, that in some circumstances, you may have an individual who's a minor, but maybe living, let's say, 10 years or more in enormous amounts of pain, enormous amounts of suffering, but yet that's excluded from the legislation as it's currently proposed. So that's the reason why, and I'm not saying we need to, but that's the rationale why many people are saying that, you know what, if we're going to have criminal code provisions on this, let's at least carve out the way that it's going to apply.
Okay, well, let's be clear about the criminal code provision that's been struck. It was the criminal code provision that made it unlawful for anyone to assist another person to commit suicide. The actual law against suicide had been repealed many years previous. It's simply about assisting. Are the ethics of the medical profession and the regulation of the medical profession enough to provide adequate guidelines around this, so that at the end of the day, if doctors won't proceed, then that's the end of it with any given individual? Is that enough, or do we actually need a law that allows people who go, so in air quotes, go too far, allows them to be prosecuted?
What do you think, Mitch?
Well, I think if you strike that out, then it's not necessarily just the medical profession that's going to be dealing with this issue. You're going to have a lot of DIY who are going to say, hey, you know what? My parents, my kid, my brother, my sister, there's no law against me helping them. So let's just move forward. So I think, the problem is once you open this can of worms, then it gets really, really, really messy. And it was, with all due respect to the Supreme Court of Canada, they've now opened up a huge can of worms that is going to plague us for decades and decades, because it's a lot easier to just have the prohibition and be done with it instead of trying to make a number of rules that are going to constantly get challenged for years and years and years. And it's going to be, where do we go here? Where do we go here? I mean, it's just impossible to really put guardrails on this thing.
Are you basically in favor of continued prohibition, or where do you stand on this?
Yeah, I'm okay with the prohibition. I think that's easier and a more consistent approach. I think just from a moral perspective, I have difficulty with opening this can of worms and just normalizing suicide.
So basically, you're concerned about the nanny state getting involved in creating laws that will allow people to do this within certain limits, and you would simply prefer that the nanny state prohibit it altogether?
Yes.
Okay, good.
Absolutely.
Where'd Bob go?
I think there's a limit to how much personal freedom and personal autonomy that we should be having within certain things. We can.
Conservatives argue in favor of that.
I guess the short answer is if since we're legalizing marijuana, we'll just all be high all the time and pain will go away.
So,
Let's get solved.
let's take a step back, because I think there's one point that Omar raised as sort of a framing device, which I think is kind of useful here. Under the common law system, anything that isn't explicitly prohibited is allowed. And so I'm not convinced that, the quote unquote Morgenthaler approach is inappropriate here. And I'm not sure that the Morgenthaler approach hasn't sort of been a benefit to, those who need abortion services. And it strikes me that, that's an entirely sort of appropriate approach to take here, that where we're butting up against, really thick issues of morality, mortality, the continued existence and continued suffering of individuals who are in really dire pain. Again, I'm just not certain that it's the legal framework which is required here. By my lights, the status quo on abortion seems to be functioning perfectly well. And it strikes me that would have been a viable sort of option to pursue here, where the Supreme Court said, look, the provisions on assisting suicide are struck down as an unjustifiable limit or infringement of the Charter, and that's it, right? Like, that's just all that we have to say about this. Like, we as the legal sort of sphere doesn't need to intrude any further in that, and we just leave it to the doctors, and we leave it to the medical community, and we leave it to ethicists to come up with, the guidelines and the parameters of how these sorts of decisions are going to be made. And again, it's still illegal to kill somebody, right? So, like, if somebody's committing homicide, they're going to get charged with that. I'm just not sure what we're adding to the process by introducing another criminal prohibition, which goes above and beyond that homicide step and speaks to, again, what strikes me as primarily an ethical issue.
Well, from my perspective on this, the Trudeau government has chosen to proceed very cautiously. They haven't gone as far as the Supreme Court of Canada might have suggested or certainly permitted, but I think they're taking an incremental approach to this, and they'll start it at one stage and expand it or not expand it based on experience on the ground. I'm not sure whether that's the right move legally. Politically, seems to be a pretty prudent way to deal with sensitive new ground. At the end of the day, though, we're talking about people having the ability to look forward to a period of illness without the terrible fear that it could go on forever. And I, for one, feel some reassurance as a Canadian, knowing that the option may be there for me if I want it at a later stage, when life just ain't worth living anymore. So shall we move on from there? Or any closing comments on this topic, guys? So
I'm just going to add, I think they're right that we're probably going to revisit this regardless, one way or another.
You mean in the sense that this is going to go back to through the courts?
Sure it is.
I think so.
Sure it is. And it will be expanded or narrowed. And, we've seen the court swing from one direction to the other. A different court could swing another direction or all the way back. We really don't know what to expect. But like I say, for now, I might lean in the direction, Bob, where you are, that no legislation is better than bad legislation or halfway legislation. But I guess time will tell. And this is a new period for Canada on these topics. Let's talk about the Panama Papers. The Panama Papers are 11.5 million leaked documents detailing financial and attorney-client information for a whole bunch of offshore entities. The Panama Papers are essentially documents that were stolen or intentionally leaked or hacked from a law firm. We still don't really know the story of how this Panamanian law firm's entire database of solicitor client information has made it onto the public stage. But here we are right now. We're seeing all kinds of things emerging from this, including many public figures, political notables, and financial notables being exposed as having some activity which may be suspect. Mitch, what do the Panama Papers bring to the party in terms of informing us further? And are you afraid about the way this documentation came to be obtained? And should it be used at all?
Well, here's the takeaway. I think, regardless of how you feel about people avoiding tax in either illegally or legally, is that law firms are not the safest place for your data. That law firms do not have the protection that they claim to have. We've seen, recently also in the United States, large white shoe firms in New York get hacked for the purpose of finding out which deals they're working on. So, I think this is starting to strip away the illusion that law firms actually know what they're doing in connection with cybersecurity, and clients, certainly corporate clients or clients who have very sensitive information should be asking some pretty serious questions about the safety of their data, whether it's, hacked into the system or whether somebody just loaded up a few USB keys and walked out the door. It's a huge security issue. That, for me, is the biggest takeaway from that, is that your data with your law firm is just simply not safe.
Do you think their data would have been safer in the cloud?
But is that safe?
You know what? It really probably would have, if you had a proper cloud server where you could have an audit trail of who has access and it's properly encrypted and properly protected so that only, these three people have access to that data. I think that's probably would have been a lot better idea. But law firms, particularly large law firms and international law firms are really feel that their internal IT guy or guys or women have more expertise than Microsoft and Google and everybody who just does cybersecurity 24/7. So that to me is the biggest takeaway, and it's something that people really aren't talking about. Everybody's more bent out of shape about who's on the list, what money are they secreting out of the country. As law firms, we're entitled to look at legal ways of getting money up and setting up whatever structures we feel can meet those tests. But in terms of security, that's my takeaway.
So a few different observations. I mean, one is, as somebody who sort of was watching the kind of pre-release hype on this, I think it's absolutely fascinating that the only sort of significant fallout that at least has reached my sort of level of media consumption is the Prime Minister of Iceland resigned. This was supposed to sort of shake the foundation of civil society throughout the world, and we've got one guy in a country that has 500,000 people who's resigned. I think the other thing is, there's been echoes of the legal commentary online, and posing that sort of perennial question of, well, where were the lawyers, which I think was first sort of mooted about Enron and WorldCom 15, 16 years ago. But to sort of pick up on what Mitch just mentioned, I haven't yet heard anybody describe anything that the lawyers involved have actually done wrong. So it strikes me, and in fact, the CBA, went to the wall to, ensure that lawyers, could involve themselves in precisely these kinds of activities, and that we are not subject to any financial reporting, and we're not subject to money laundering legislation. So I'd be interested in hearing if anybody thinks that anybody has any of the lawyers involved in this have actually, done anything wrong or done anything which is worthy of condemnation. We might think that the people involved, the clients who have arranged their affairs offshore or whatever in order to avoid tax, they might have violated whatever legislation they're subject to, or there may be sort of moral or fairness concerns or considerations that they've fallen afoul of. But in terms terms of what the lawyers have done, I'm just not sure that there's any sort of there or there.
Omar?
I think there's a couple of things the lawyers may have actually done wrong, and I'm going to point out a few examples. We don't actually know how, in particular, this information was obtained, which is right. Okay, it could have been through a USB, but there has been analysis of the firm and the type of things that they're doing. For example, they were using WordPress 4.1, which dates to December of 2014. In other words, their website was not updated. All it is one click on WordPress and you can update your website. And that particular version of WordPress actually has a number of vulnerabilities which could have been exploited and could have been the way that they were actually lost their information. And then it's still using WordPress 4.1. They were using Microsoft Exchange from 2009. And if they're running an Exchange server from 2007, again, there's known vulnerabilities there where they could have been hacked through the email server. So in terms of the lawyers and their own responsibilities, I think we can say, you know what? It's not about necessarily the legal transactions that they're involved. I'm not even going into that. I'm looking at simple basic steps of protecting your client's data, which is keeping your websites current and trying to implement the most up-to-date version of any software you're using. And that alone will eliminate many of the risks involved.
I kind of feel like this conversation is beating around the most important bush here. There are so many questions here.
What's that?
First of all, if this information should lead to prosecutions, should the Canadian courts allow this evidence in, given the way it was obtained, my vote is no. But lest you think I'm leaping to the defense of the people who are storing their money in Panama and elsewhere, I'm not. What this is really exposing is one of two things. Either the corruption of our tax codes that make it easy for people to take their money out of the country and avoid their tax liabilities. So the very kind of legitimate structuring, Mitch, that you're referring to, and it is legitimate and it isn't unlawful in most cases, maybe it's time you need to review that. But as well, I think that the role of the press in getting together as a collective to sort through all of this information, to find the really juicy stuff, that to me is absolutely fascinating. So do you think, should the courts be able, should a Canadian court be prepared to allow evidence from this data leak? Should it be relevant to a matter that comes before the courts for prosecution?
Well, hang on. Is it even going to go to the courts? Because CRA is going to have that information and they're going to look at it and say, end of discussion, we're going to assess you. And I'm not sure how a court can say, yes, you're in breach of the income tax laws and you're found out. I don't see how you can just ignore.
Well, I think you're
that
right.
fact.
It would be up to the.
I find it difficult to. I mean, like it's how different is it from a spouse, in a messy divorce, giving CRA all her husband's files of his secret bank accounts in every offshore haven and saying, "Bam, got you."
How different is it? The wife didn't go into the husband's law firm and steal paperwork from the husband's law firm and then give it to CRA. Would that change the equation for you, Mitch?
No.
Okay,
no.
So that nanny state is okay too then.
I have no problem. I have no problem with CRA tracking this down.
So, do you have friends at CRA?
I do not have a strong feeling against some of these things. I'm okay with it. I think there's a purpose to government.
That's big of you.
And if it lowers my taxes in the long run, I'm happy with it.
If we're moving out of the CRA context, though, because the information that's found in the Panama Papers are interesting because they can be applied in a number of different ways, including potentially criminal convictions. I mean, for improper use. There's a whole bunch of different applications here. The concern of the applicability here would be exclusion of evidence. And the Canadian Charter operates in a very, very different way than American evidence law, for example, where the fruit of the forbidden tree, if you will, is excluded in American law. So in other words, illegally obtained data or illegally obtained evidence will be excluded. Canada, we have a far more nuanced approach where we say even where there has been a charter right that's been infringed, we look at whether or not the court system or the justice system would be brought into disrepute as a result of the admission of that information. And so for me, this raises a number of questions. First of all, who actually breached the charter rights? We don't actually know who actually hacked the law firm, who disclosed the information. It wasn't the Canadian government, last time I checked, from anyone's indication. So I don't know if the Canadian government would have been the one, or any of their agents would have been the ones responsible for the breach. Again, it's an unknown question. Second of all, does it actually bring the justice system into disrepute through the inclusion of the evidence? I would actually say potentially, especially given the very strong public interest in the content of the Panama Papers and holding people accountable and greater transparency in Canadian society, that we're more likely to bring the justice system into disrepute by not using this information. And so I think on a balance there of the public interests, I don't think a 24-2 charter analysis of this would result in the exclusion of this information.
Would you feel differently if this was?
Yeah. How different is this from? Sorry. What about? I mean, this is no different than a whistleblower.
Well, wait a second. What would you, Omar? Would you take the same position?
How different is this from
the same position, Omar, if this data was stolen from Bob Tarantino's firm in Toronto? Is it that it's some remote Panamanian firm that allows us to wash our hands of the protection of solicitor-client privilege?
No, I don't think it's about solicitor-client privilege. I don't, because again, it's also about unknown parties, and then this information has then been disseminated everywhere. I think the issue of solicitor-client privilege is an entirely different issue. First of all, second of all, even where there is, and this is a Canadian context, even where something may have initially been obtained by illegal and improper means, it doesn't mean that law enforcement or agents or inspectors can't use that information to then independently go and confirm or obtain the information.
I'm just asking you a specific question. If this data leak came from downtown Toronto, how would you feel about it being used in aid of prosecutions in Canada?
I'm not saying that I'm all for it. I think it depends on the purpose of the prosecution. And that's why I said that the rule that we use, at least under 24-2, is the public perception of our justice system. Does it bring the justice system into disrepute? So that's what we're trying to evaluate here, at least in this context. And I don't think it makes it different whether or not it's a firm in Panama or if it's a firm on Bay Street in Toronto.
One of the things I always find fascinating about...
don't you think that if Canadian courts declined...
Oh, sorry. I was going to
Sorry,
say,
Bob, you were saying.
One of the things I always find fascinating about the law in this area, and not just in particular on this sort of topic about admissibility of evidence, but about the, bringing the justice system into disrepute test. I always find it fascinating that that's really just a proxy for what the judge charged with making the decision think, right? Judges never go out and ask people. We don't really care what anybody thinks. We don't sort of ask your average person on the street, hey, do you think this is going to bring the justice system into disrepute? It's all within sort of the cabal here, right? It's what do the judges think about this? And then really that just is sort of an extension of, well, what do the lawyers think about whether it's going to bring the justice system into disrepute? So my comment really has very little to do with the particular issue of the Panama Papers and the disclosure or use of them, but I find that it's amazing how we as lawyers talk about these things and think about these things in a way which just we use these sort of phrasings which really have no bearing or no connection with how the actual sort of community at large would actually think about things.
Yeah, so kind of like ABS. Is that? Are you going sort of there as well?
Feel free, Mitch. What's ABS, Mitch?
Sorry, are you pro ABS, Mitch, or are you against it? I can never remember.
Well, I've been really hedging, as you know. Alternative business structure.
Let's just break the internet now.
It's really simple.
ABS.
We're going to have it whether we like it or not. I think, Garry, that was one of your topics when we chatted earlier, is we're moving to entity regulation. So we're having law societies in Nova Scotia, British Columbia, and Ontario, reluctantly joining the pack and saying, we're going to regulate the entity. And so once you start regulating the entity as a legal services provider, there should be not much difficulty in caring about who actually owns that entity because it's being regulated in the type of services that it's going to be given. So we are going to see that in Canada. You heard it here first, probably in the next 5 years or less, at least one jurisdiction, and it will roll across, and we'll all be better off for it. That's my speech.
For those,
Have you guys heard of Rob Lapper?
No.
Sorry?
Do you guys know who Rob Lapper is? Rob Lapper.
No.
Yes.
Who is he?
Rob Lapper is the CEO of the Law Society. I would hope you guys know who he is.
I feel like I should have known that.
Mitch and Bob, you've never met him because, well, no, I'm just saying, I mean, if you're going to be a bencher and all, that would be the kind of thing that you'd want to know, right?
It's true.
So, in any case, I think this is. I'm going to highlight a couple things here. Rob Lapper actually had.
That was like a zing, wasn't it? That was a zing.
I think it was a zing. Yeah.
Oh yeah. Oh, that was more of a jab. Okay, but Rob Lapper recently at a reception in Toronto actually said that legal reform or major overhaul of the legal system is not going to be possible without a capital infusion from the outside. And so my question to you is, how the heck is that going to happen without ABS, or as Mitch puts it, entity regulation? So if Rob Lapper, the CEO of the Law Society, is saying, look, if you want change, we need a cash infusion, a private entity cash infusion, more likely than not, I think it really signals where things are going. But I want to tie in Bob and Mitch's venture run just in a second here. And the number one reason why many of the, let's say, the alternate candidates or the candidates who want to have reform in the legal community, why they may not have been successful, was of the mobilization of organizations like OTLA, which said, if you are for ABS, we are against you as a venture. And so if we go back to where we have the CEO of the Law Society, who seems to be open to the idea at the very least, and then significant portions of the bar that are so close-minded to it that they say, we will vote against you simply on the basis of that platform. I think this is the perfect storm, and we have some very interesting days ahead of us in terms of how this is going to be a tug-of-war between different members of the bar.
Yeah, I mean, all quite frankly, that was disgraceful what they did, and to take a position like that and try to really fetter the discretion of convocation in advance is really, there's no other word for it. It's disgusting, and it's contrary to everything that we should be doing as lawyers. The problem, is not with Rob Lapper. It's not the problem with the staff of any law society across Canada at all. The problem are the benchers, and that's who is the board of directors, and those are the people who make the decisions and give direction, and they're the ones who also say, no, we're not going to do that, thank you very much for all your hard work and studying, and we'll give you a nice watch when you retire, and we'll take you out for dinner, but we're not really that interested. So that the problem is with the elected officials, but this is all going to be mute, because as soon as one province moves in that direction, we will have no choice. So benchers in Ontario, enjoy your moment of perceived glory. But once Nova Scotia goes and the Western provinces goes, you are not going to be able to sit back and say, no, not on my watch.
Okay, but
that's where this is going to play out.
I'm inclined to agree that the future of the administration of justice requires the infusion of new capital. But the infusion of new capital needs to go into the court system. I still don't understand how it's going to change anything when you get a bunch of large corporations creating some new approach to retail law. I don't see it. Is it going to be about outsourcing and offshoring? Explain to me, Mitch, how this matters.
You're 100% right. There's two pieces to the puzzle, right? And interestingly enough, spoken at OBA conference just the other day, where we had two elderly judges, one from federal court, one from superior court, who were running electronic trials and insisting on every single document being electronic and tracking it and getting rid of paper. So that's just the start. And they said over and over and over again, we cannot get our colleagues on the bench to follow our lead. They refuse. They will not do it. And they pleaded with the lawyers at the OBA conference, said, if you ask for electronic trial, if you ask for this, they will have no choice but to give it to you. But you need to ask every single time jointly as counsel to say, this is what we want. Please put it in the order that we will be going fully electronic for this. So there, that is, quite frankly, disgraceful on the judiciary as well, that they are so close-minded to ways that will save costs for clients. And you're right. I mean, there's two sides to the coin. We can do as much as we want. There will always be, at least for that part of law that involves high conflict areas, but all other areas of the law, that's litigation is not the only thing we do.
It's just, it's interesting because the best arguments I always hear in favor of ABS is that there's going to be technological innovation and the efficiencies that innovation can bring to the system are going to be miraculous. But the bottleneck isn't lawyers when it comes to efficiencies. It's the court system. And for judges to say the problem is other judges is ridiculous. The problem isn't other judges. The problem is the government that refuses to properly fund these projects to automate the courts. And it's not really up to the judges. I'm sure the regional judges, the senior judges will have no problem with automation once it's made available to them, because it's going to save huge dollars in the court system. But I will, for one, say that I think that our rules of professional conduct should be amended so that the unwarranted use of paper will be deemed professional misconduct. Anybody want to disagree with that?
Yep.
Part of the
I think that's
challenge
pretty heavy-handed.
with ABS
Garry,
is that it's not just two conversations; it's about like 10 different conversations, all intermingled. But I think, Garry, you're exactly right, and I'm astonished at the quiescence of the legal community in this country. Like, we make no fuss whatsoever about the fact that the courts are drastically under-resourced. Right? So we not only can barely get the government to actually appoint judges, right? Like, there's like a systemic, shortfall in federal court appointments. But both provincial and federal governments are like woefully inadequately funding the system, and we do and say nothing. Right? Like, if you want like a perfect encapsulation of why it is that people outside the legal community could be justified in viewing us as, not doing everything we possibly can do to achieve, justice for this country. It's the fact that, for whatever reason, we're like meek little mice who say nothing about the underfunding, like nothing, right? And that goes from associations up to, the law societies themselves. And not to say that there aren't arguments being raised about that by various organizations, but they're done in the most sort of, sotto voce way, where it's just like, well, it'd be really nice if we could get some more money from you guys. Like, that's not, how change is achieved in this area. And the legal community seems to have internalized this notion that, well, the governments are never going to fund us adequately because there's no sort of, political capital in doing that. And it's absurd.
Omar, you got it? Omar, you have anything on this?
I always like to have a dissenting voice, and I don't think that problems in life or in society are necessarily solved simply by throwing more money at them. So I don't think our problems with our courts, with our judiciary, with everything being backed up, will be magically solved simply by increasing funding. I think what needs to be done is a complete rehaul, and I'm pretty sure many of you guys actually are on the same page with this. And there's a number of different ways in which we can do this. Part of it can be online resolution. Part of it can be early mediation. It can be pre-litigation mediation, which is mandatory. The creation of more tribunals to divert some of these problems away from the court system to begin with. And I actually think we need to have a much more stronger cost regime as well to actually ensure that frivolous litigation is actually kept out of the courts. So, or frivolous behavior is kept out of the courts as well. So I think there's a number of things that need to be done in terms of our structure and the very fabric of our legal community, which doesn't really require any money at all. It requires us taking a step back and saying, is there a better way for us to solve problems for our clients?
Well, my 10 cents on this is that the problem begins with politicians and legislation. Politicians refuse to write clear legislation that is easily implemented where necessary by a court system. Instead, what we're left with is foggy wording that requires judicial discretion on far too many points. We've now reached a point where the average Canadian simply cannot afford to use the judicial system. And until the legislation changes, until we simplify, and getting back to what Bob, you were saying earlier, get the government out of things the government doesn't need to be into. I think we're going to continue to have these problems. I don't think ABS is going to solve it. I don't think that additional technology is a panacea. But at the end of the day, I think our problem is the legislation itself. It's not written to be simply implemented and interpreted.
But why are we blaming the government for that? I mean, every attorney general, and I've actually spoken to several of them in Ontario successively, every attorney general in Ontario is actually trying to do some reform of our legal system. And they do this in conjunction with the legal community. So they have rules committees that are comprised of lawyers who they work with in consultation. And they consult the bar and they consult professionals in the legal community constantly. And the number one thing that keeps on happening year after year after year, attorney general after attorney general after attorney general, is enormous amount of resistance from the bar itself. And so if we have obscure rules or rules which don't appear to make a lot of sense or provide perhaps too much discretion to the judiciary, I would actually turn around and say that, you know what, part of that responsibility is also ourselves, and a lack of introspection and perhaps an overly inflated sense of worth in terms of the value that we provide to the public. And that requires a lot of introspection. Okay, I'm introspecting. I disagree. Of course, I think it's a nice speech, but I don't think it's true, and I don't think the attorney generals necessarily have sway within government. But I think most of us are familiar with Daniel Katz's work. We are moving in the direction, I believe, of most legal questions or many legal questions being decided on an automated basis. I've seen in the family law system the implications of the child support guidelines that created certainty and took child support decisions out of the hands of the judges for the most part, and it created peace, less litigation. I think that's a good thing, and I think it's a good model for all of us to be following, including our legislators. Why be vague when you can be clear?
Yeah, one thing.
Well, no, but then
sure. So I think one thing which I find curious about the approach to this, it's this notion that somehow the legal system shouldn't be the forum for the resolution of disputes, or at least the formal court system. And I think that's a really bizarre sort of stance for lawyers to take in particular. We've seen, so like for at least since I've been in law school, so at least 25 years, we've seen the legal community as a whole and governments as a whole try and push as much sort of dispute resolution out of the court system as possible, right? So we have like almost almost a quarter of a century of concerted effort trying to get stuff out of the court system. And I think we lose something when we do that, because our courts are supposed to be sort of the site of communal dispute resolution. And so when we lose decisions, the common law sort of withers on the vine, right? And when we lose faith in the ability of the courts, the formal court system, to actually resolve problems in society, I think we're losing something really valuable in that process. And so if we shunt everything over into private arbitration, and if we try and shunt everything to sort of mechanical, computerized decision making, I think we're losing a lot of the human touch. I think we're losing a lot of the communal, the assertion and the acting out of communal values.
Just to clarify that point.
But you're
Sure.
speaking like a lawyer. I don't think people care about all of that philosophy that you just espoused. I think people I want my things resolved. I like it resolved in a way that I can afford. I like it resolved quickly. I don't want to wait, 2 years, 3 years, 18 months, whatever. I don't want to go to trial and have to wait 8 months for a judge to finally pick up a pen and give me a bloody decision on it. And I recently had a case like that where it was atrocious how long it took to get a decision, which was actually wrong, but we won't even go there. People just want it done quickly and affordably. And if the current system is not giving them that, why cling to it?
But I think
why not
quick
move
and
to something
affordable can be done within
Bob, were you
the structure of the legal system.
But we haven't been able to do that.
Yeah.
In fact, it's just getting worse. Self-reps are ridiculously high, specifically because the court, as a communal decision-making body that's accessible and affordable, is something that's outdated.
Well, it is.
So I
It
don't have I don't have a problem with the common law getting rid of a common law and actually maybe going to a civil code kind of system where we have a codified set of laws and hopefully that will be easier to manage.
Like,
I don't know, but I'm just
do they not have an access to justice problem in Quebec?
I don't know. I honestly don't know.
But,
But when you have a codified set of laws, that lends itself to an online dispute resolution, which will be an AI-driven court, which will then say, okay, here are the rules. I'm just going to apply the rules to this set of facts. Boom, done. I'm not going to have to worry about common law decisions and working about how these 4 cases interplay with each other and come up with some rule that
Omar,
may
you
change.
have thoughts on this?
Yeah,
No,
I know it's heresy.
I think
Absolute
that
heresy.
drastically
Absolutely.
underestimates how complicated human affairs are.
the beauty of the common law. Okay, so legal theorists, they of course, they're
The beauty of the no normal people says that. Regular people don't say the beauty of the common law.
I would hope people with a law degree.
They don't even know what it is.
Okay? But the supposed beauty of the common law is that it is flexible and it's adaptable and it changes over time, and it's the rich fabric of all of this case law. So this is what Bob is talking about, that we need those decisions. That is the rich tapestry of our legal legacy. And I think if we don't have that, I do agree with Bob to that certain extent, that we need to have that. In fact, from a business perspective.
So how do Quebec lawyers feel about that? How do lawyers in France and EU countries feel about it?
I agree.
Are you suggesting that they're missing out, that they're losing out because they don't have this rich tapestry?
You know what? It might be
They're
egocentric,
colder at night?
but there are people who actually look at the fact that there are other jurisdictions around the world who may have had a choice and may have had a greater inclination, perhaps because of how widespread the English language is, but they actually choose to go with the common law system because of its ability to actually create greater predictability, and it's more flexible to the business context. So the common law is good for business. I'm surprised I have to make this case for you, Mitch.
Well, and I would say from my experience in the courts, the court system exists essentially for the very rich. They're the only people that can afford to use it. And while they're, in some cases, exiting in droves for private arbitration, go spend any day in Ontario courtrooms, and you're going to see a lot of very, very wealthy organizations and individuals using the public purse to fund the resolution of their often very silly disputes. I'm not sure that we can afford to do that anymore. And whether we like it or not, I think we're going to have to move in the direction of expert tribunals that are going to be able to decide complex issues, and some kind of an online dispute resolution system based on simple legislation that's enacted by the politicians of the future. I think that's where we're going. And I don't see the problems we're having now being resolved until there really is a serious rethink of our civil justice system in particular. So, gentlemen, believe it or not, we are running out of time. It's been a very quick 57 or 58 minutes. How are you enjoying the Blob experience so far?
All good.
It's great. I like that I've got 15 hand claps and Bob's got 12 and you guys have 10.
How many of them?
I guess that means I win.
How many hand claps did you give yourself, Mitch? You kept going.
I'm just happy.
Maybe 14.
You kept cutting out, and every time you came back, you had another 3 hand claps. Okay, I'm suspicious.
Oh yeah, now Joy's giving claps to everyone.
Oh, is she?
There you go.
Okay, well, I don't have any extras. I'm stuck at 10 with Omar. It's been a blast. We did have some issues, technology issues. The audio sometimes was breaking out on us, and I see you guys had to come back in a few times after having technical problems, but things pretty good. Pretty great way to have these conversations, and a heck of a lot easier than getting everybody together in one place. So, any closing comments, Mitch?
Yeah, I'm happy to see you guys, but I just wish I could stare deep into Mitch's eyes. That's all.
Yeah.
This is my Bob McCowan, persona. So this is now my online persona.
Is
the
that
sunglasses.
Bob McCowan of the Law Society?
Yes, that's
Okay.
right.
Does anybody else remember from the 1980s there was those Maxell tapes advertisements? Yep. That's what Mitch is. Mitch is the guy in the Maxell tapes ads.
I was only 5 years.
I see. So Mitch is sort of like classic lawyering.
Exactly. Yeah.
Classic, yes. We're going classic.
Ray-Bans. Wasn't that what was Tom Cruise wore Ray-Bans in one of those movies too? Top Gun? Is that what it was?
No,
Top Gun.
Okay, well, you're
Risky Business.
Top Gun.
You're our Tom.
And Risky Business.
Okay, Risky Business, right. You'll be our Tom Cruise for the night. Omar, any final comments?
These are my submissions, Your Honor.
Yeah, I'll reserve. Okay, guys, good night. Thank you very much. And we will do it again.
Guys.
Take it easy.
Cheers, guys.
See ya.
Okay.